Hey guys, what is up? It's Dusty here, and welcome back to another crypto video. Today, we have some breaking news on the Ripple v SEC lawsuit. The judge has just made a decision on a really important part. Specifically, breaking news. Judge Netburn denies the SEC's access to Ripple's legal memorandum, dealing a huge blow to the SEC. And this, guys, is coming from a defense lawyer who has always got all the documents first and is usually kind of not necessarily unbiased, but providing really good updates factually, objectively. And I really love this, man. Make sure you guys press the like button if you are an XRP holder. I'm going to try and explain exactly what this means and kind of what happened and what it means for the future. I'm going to explain everything, but side note. Since these videos usually do good, if we can get to 4,000 likes, I'm giving away $360 worth of crypto because I still have 3 times $120 left. So make sure you press that like button, make sure you subscribe, make sure you comment something down below. That is all that you have to do. And shout out to Spinal. I'm hoping, I'm not sure. Spinal Poeta. I'm not sure how you pronounce that, but thank you for the notification right there. It just came out like 30 minutes ago, 22 minutes ago. So, decision denying access to legal memos. Yes, guys, we had a hearing, which is basically Ripple, the judge, and the SEC a couple of days ago. We, of course, attended. We did really well in trying to transcribe everything that happened. But, without further ado, it basically was said in there that the SEC wanted some documentation from Ripple. They wanted specifically the advice that Ripple received from said parties, right, that they refer to. Why did they want that? Why did it matter? Well, the SEC claims that Ripple didn't need fair notice, and the SEC also claims that Ripple knew exactly what they were doing getting into all of this. And basically, the question pops up, does what Ripple think of things, does what Ripple's mindset is going into things matter for this lawsuit? That's a big question that you might have. Does whatever is in Ripple's mindset have any bearing on the actual result of the lawsuit or the actual matter at hand? The SEC would like to argue yes, Ripple's side would like to argue no. And that's also kind of what this issue is all about, because Ripple is saying they don't need our legal advice documentation. They don't need it because why does it matter? Even if the result is what they wanted, it can only aid them in what they are looking for. But it's not actually relevant here because, well, we're not bringing it up. So why are you? It's not relevant. You might find something in there which is for a different cause that you might think of, but it's not relevant because we are not bringing up that issue. And specifically, the information that they have, quote unquote, hidden is basically Ripple has, again, just logically, right? They have just talks with legal advisors. It's not that crazy. And they are by default privileged, which basically means they're not given out to the public because you have a client attorney privilege. That's also what's said in the document here in a couple layers down. Let's quickly, it's really in here. Attorney-client privilege is what it's called. Now, again, the SEC said, well, since you have already used this information for a couple of parties and since we think it's relevant, bring it out there. And now the judge has decided, no, you don't have to. So I'm going to quickly read through this. It's just like 5 or so, 6, 7, 8. We don't need to read everything, but let's quickly go over some of the points here. So let's quickly start because I thought it was really interesting. Result, by the way, and if you're kind of wanting a quick summary, this is really extremely positive. It's really extremely positive because this would have been only bad news for Ripple if they got it. Why? Because there's actually nothing positive that they could have gotten out of this. Ripple's just at a big disadvantage, and the judge now saying no to the SEC does show a lot for the future. She understands the case. She understands exactly the issue at hand, and she knows as well that Ripple's mindset going into all of this, it has no real bearing on the things, right? Now, let's read the official conclusion. The SEC seeks an order compelling Ripple Labs to produce all communications constituting, transmitting, or displaying, or discussing any legal advice Ripple sought or received as to whether its offers and sales of XRP were or would be subject to federal security laws. And the motion is denied. And I love to see that, guys. I really love to see that. So let's quickly read this first part because there you'll see how this kind of contributes to fair notice. So federal district courts have broad discretion in deciding motions to compel. Rule 26 states that parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense. So in this specific case, non-privileged basically means, stuff that is not necessarily falling under one of those privilege. It's not privileged. Like if I have a discussion with you and we write something down, it's not necessarily privileged. So parties have all the rights to basically obtain all that information in this current phase of the lawsuit, the discovery phase, that is relevant to any party's claim or defense, right? So both sides. The party objecting to a discovery request bears the burden of showing why it should be denied. So in this specific case here, Ripple's side is the objecting party. They have to explain why they can object this. Once more, this is only for non-privileged material though. And quoting something, Ripple asserts that the SEC's requested communications are protected by the attorney-client privilege, which has not been waived, and the SEC counters that Ripple put its attorney advice at issue by asserting a fair notice defense, and that the SEC is entitled to test and rebut this defense. So, once more guys, that's actually the most important part of this whole entire document. The SEC is trying to say, you know what, this is not privileged anymore because you're bringing up this point of, hey, SEC should have given us fair notice, where the SEC is kind of countering that, saying we didn't have to give it to you because you knew exactly what you were doing. And to kind of, confirm that claim, which is, by the way, would only aid their motion to strike one of Ripple's defenses, the fair notice and I don't know the exact defense anymore, the entire name, but basically the fair notice defense. They would have used that to strike it down, or at least try. That's basically what they're saying right here, right? It would have helped them strike that down. That's what they are saying. The judge has denied that. Basically, given the SEC less firing power, big negative for them, because once more, guys, like I explained in one of the videos earlier not yesterday, I think it was, or maybe the day before already, we explained how the fair notice defense is by far the most important defense Ripple has. That was built up by a couple of points. One point being, fair notice is so ridiculously easy. If it's fair notice, if they didn't give it, boom, whole case is gone. If you didn't give fair notice before the lawsuit, specifically the SEC, you have nothing to build on. The case is just thrown out the window. That's one part, right? So if they agree, the judge, that they didn't give fair notice. Now, again, the judge is helping out to make sure that the SEC can't get rid of that defense, which is good. A second part would be, well, if Ripple gets the fair notice defense kind of, thumbed up right now, then any cryptocurrency company in the future will be able to use that defense too. Specifically, the higher the court, the better. And even if Ripple right now gets denied, they can always go a court higher. And if it gets approved there, then still any crypto company in the future can use that defense, which basically means the SEC is going to have a very hard time suing any other crypto company from that point on forward. From that perspective, almost any any crypto company should be helping out Ripple right now on this fair notice defense ground, because, as I've said before, I think most cryptos that you and I know will be going down with the exact same ship. If Ripple goes, most other cryptos are going, and it's a really scary thing. Yet people seem to kind of ignore that fact. They like to keep it at Ripple and just say, oh, no, it's just Ripple. Ripple's a centralized piece of garbage. Doesn't matter. Because if you can't really point out exactly why Ripple/XRP is centralized, I mean, Ripple is a centralized company, XRP is really decentralized. We've covered that tens of thousands of times. If you really can't pinpoint exactly why, if you're talking about the UNL, which a lot of people do, that is actually going to get you in so much trouble, because so many different cryptos out there follow under some same sort of parameters or some same sort of system where it's going to be like, if you think Ripple is so many cryptos will go. Let's just kind of summarize it to that one. Right, and then basically that point is also, if the SEC wins this one, the fair notice defense basically is going to be extremely bad for every other crypto company coming afterwards, because they're going to all have to face an uphill battle. And yeah, the first part here is basically, once more, the privilege argument. Then at issue, waiver of attorney-client privilege. It's basically the same thing. I'm not exactly sure why that changes. Let's quickly see what else we got. Application, Ripple's fair notice defense. This part is interesting. Ripple's fourth affirmative defense, the fair notice defense, claims that there was a lack of clarity and fair notice regarding defendants' obligations under the law, in addition to the lack of clarity and fair notice regarding plaintiffs' interpretation of the law. ECF number 51. Ripple answer at 97. Ripple situates its defense within the Fifth Amendment's due process clause jurisprudence. And let's quickly see. Due process requires that a law give ordinary people of ordinary intelligence, fair notice of the conduct it punishes. In asserting this defense, Ripple claims that the SEC's actions and inactions failed to provide market participants with fair notice that the agencies considered XRP a security. This has two parts once more. First of all, Ripple is claiming that the SEC's actions and inaction, so basically what the SEC was doing and also not doing, didn't give people the right idea, nor a proper idea of the whole situation. Then again, though, they refer to market participants, and this is a key point right there. Ripple refers to themselves as market participants. The SEC refers to them as just the company issuing securities. They don't really refer to it as market participants. And that entire point is actually also the question of, should Ripple's mindset matter or no? Or are they basically the same like us? They just have a lot of XRP, but they're also just market participants who also have the same type of knowledge, or should be kind of based on the same type of knowledge that we have, because they're just, considered people of normal, ordinary intelligence, basically. And then another part, of course, is that, well, it should have been obvious, or they should have at least given the info out if you asked for it. And since the SEC didn't do that or didn't know themselves, then the question really gets kind of difficult. In support, it cites that the SEC's 8-year delay, which is all apparent. I mean, they've been investigating since 2013. They took action in 2020. In support, it cites the SEC's 8-year delay in pursuing enforcement action against Ripple for its alleged security violations, even after XRP was listed on over 200 crypto exchanges, billions of dollars of XRP sales transactions had taken place, and Ripple had entered a settlement with the US FinCEN that described XRP as a convertible virtual currency, by the way, which is, again, really easy to see where the difficulty lies. I mean, if you've been called a virtual currency by FinCEN, it's kind of obvious that you think you're not a security. Then again, that's why the SEC wanted the information, because they wanted to know, did Ripple actually think of themselves as selling securities with their lawyer? They wanted to kind of, build on that. Furthermore, Ripple points to a speech by the SEC's Director of Corporation Finance, in which he stated that he did not consider two digital assets to be securities, as further confusing the market. Finally, Ripple, this is, by the way, referring to the fact that some guys over in the SEC, William Hinman, Jay Clayton even as well, have publicly stated before that some cryptos are not securities. For example, Bitcoin, Ether were in some conferences called non-securities. Now, the difficult part there is that the SEC gives a public statement like that, and then later on says that that is not relevant. Whatever the SEC says publicly does not represent the SEC's official stance, and that's again where Ripple says, you're giving us a really bad picture of what exactly is and what is not allowed. Hence, Ripple also wants some information regarding the discussions of Bitcoin and Ether. Finally, Ripple alleges upon information and belief that a crypto exchange dubbed Platform A, which we don't have a name for, asked the SEC explicitly if it considered XRP to be a security. Ripple alleges that the SEC did not state that it considered XRP to be a security, and thereafter, Platform A listed XRP on its exchange. And then B was Ripple's subjective state of mind and advice of counsel are not at issue, which is just what we just said, right? Whatever Ripple thought, whatever Ripple discussed, it's actually not at issue here. And the SEC would like to argue that it is, but it is actually not. And that's again what this little section is all about. We don't need to read that. And then the conclusion is, accordingly, the SEC's motion is denied if at some point later, Ripple raises its good faith beliefs or... Wait, let's actually quickly go into this one. Let's actually quickly take a couple of seconds here. The SEC argues that Ripple's fair notice defense is an artfully pleaded good faith defense in disguise. Good faith defense, by the way, was a really big discussion in this hearing from before. They went back and forth on that, whether or not it was factual, good faith, and then referring to previous lawsuits and cases. I was not too good with that, guys. I'm not exactly sure how exactly to process that. Essentially, it characterizes Ripple's fair notice defense as one of two good faith beliefs. Either that Ripple thought that XRP was not an investment contract under Howey, or Ripple did not know that Howey provided the governing standard for whether XRP was an investment contract. That's basically what they've said. Ripple counters, however, that it's fair. Oh, I'm missing some lines. Both articulations would plainly implicate Ripple's subjective state of mind as to its understanding of XRP's legal status and would place at issue any legal advice it received on the question. Logically, right? For these two specific cases, it matters what Ripple thought, because either they thought it wasn't something, or they just did not know, which basically means that if they were discussing it, then they did know, and if they were discussing the contrary, then they did not think so. Ripple counters, however, that its fair notice defense is drawn squarely from the court's ruling in Upton, and there the defendant articulated a fair notice defense that was substantively different from good faith. After being censored for violating an SEC rule, Upton claimed that he should not be held liable for evading literal prescriptions, because the SEC knew about his firm's practices for years, but did not take enforcement action. Therefore, he claimed that the lack of fair notice that the commission interpreted its rules to prohibit his conduct. i.e., critically, Upton's defense did not hinge upon his subjective belief that he was complying with the law, but turned upon whether the SEC provided fair notice that the acts he engaged in were barred, such that a person of ordinary intelligence would have a reasonable opportunity to know that that was prohibited. And yeah, that's basically what this one is all about. Let's quickly go to conclusion though. Accordingly, the SEC's motion is denied if at some point later Ripple raises its good faith beliefs or relies upon its privileged communications in support of its fair notice defense. The plaintiff may renew its application to the court. Respectfully, the clerk of court is directed to deny the motion at ECF number 165 and 166. Now, this last part here, you might be confused about that. It basically means if Ripple at one point or another actually thinks, you know what, these documents which we have, we want to use them to build on defense. So they have, of course, this fair notice defense, or to some other degree, they want to basically make a point. Then the SEC can apply again if Ripple comes up and uses this advice that they received for their own defense or for their own good. As long as Ripple keeps it in the background and never raises this, it's basically not in the SEC's favor. It's never going to work because it's just been denied. And that's a really big blow because the SEC right now has yet another leg taken away from under them. They have almost nothing left to attack the fair notice defense. And the way it's looking, guys, it's looking really, really beautiful from the judge here to kind of poke at the SEC saying, hey, this fair notice thing, it's looking, oh, guys, I'm so freaking excited, man. This fair notice defense is looking really, really good. The more I read into it, by the way, the more I'm thinking, yeah, the SEC is going freaking down. And really, this is what the settlement is going to hinge on, by the way. Even a judge decision, it's all going to hinge on this specific point of fair notice, in my opinion, if we're talking a short term. Of course, there's longer term scenarios which might include it but not fully rely on it. A partial or fully settlement, though, might exactly be what this is all about. And that, by the way, is also a really big point for the near future. The SEC is trying, in one of the most recent documents here, not exactly sure what it's supposed to be. In one of the most recent documents, the SEC is trying to actually go after Ripple's newest, I guess, sales of XRP, which are basically conducted after they've already been sued. And that's kind of scary. Let's quickly see it here. SEC requests permitting 6 additional depositions, compelling Ripple to search records of 5 more custodians, and compelling Ripple to produce records regarding post-complaint XRP transactions and Ripple's lobbying efforts designed to create the market confusion Ripple now claims as a defense. The SEC is trying to get some new info because they basically want to circumvent this fair notice, saying, hey, even though we didn't get fair notice, maybe, right? Ripple still conducted their stuff now that they did get the fair notice. So that's, you know, they're trying their best. I don't think it's going to work out. This is a really huge blow to the SEC. I'm really happy to see that. From James to say it like that really puts a smile on my face because he's never used these words before. So you can also see in terms of attention how big this is, and I quickly retweeted it as well to make sure you guys are all up to date. This is a really big deal, guys. This is a really, really big deal, and I'm really happy to be able to share it with you guys. But we can be bullish. Yes, this is really good.